Page 28.
You'll get better stools for your juniors on Monday. Only for today. If it could bear my weight, I think it can bear your weight, because my weight is a little more because I don't run around as much as your juniors. But my weight is a little more because I don't run around as much as your juniors. But
not weight going by, not the physical weight,
no, I'm talking physical weight.
Because sometimes we have seen your lordship's portion of foods, so, yes, weight, yes, but not physical weight. But we are great. We were discussing that only. That's really a great gesture. We are immensely grateful. Page 28.
Sorry.
But here, so far as entry 8 is concerned, the Constituent Assembly debates does not throw much light. But I want to show those 4 stages again here also, to show how this was clubbed, with what products it was clubbed. At the foot, Government of India Act 1935, I have shown the devolution rules had both the entries, taxing and regular entry. Intoxicating liquors and narcotic drugs. That is to say, the production, manufacture, possession, transport, purchase and sale of intoxicating liquors, opium and other narcotic drugs, but subject as respects opium to the provisions of List 1 and as respects poisons and dangerous drugs to the provisions of List 3. But then draft by the drafting committee. Intoxicating liquor and narcotic drugs, substantially the same. Your lordships may consider avoiding that, ignoring that. Now kindly see, my lord, draft entry 40 was placed before the Constituent Assembly. There is a short debate on the same on 2nd September 49. It may, however, be pointed out that the debate dated 2nd September, on which entry 8 list 2 came to be finalized, had a tremendous impact of the earlier debate dated 19th, 23rd, 24th, November 48, while introducing Article 47 as one of the directive principles of state policy. The debate which took place regarding draft entry 40, list 2, that is present entry 8, is as under. But your lordships can skip. Nothing much will assist your lordships. Now, kindly directly come to page 31. There is the very extensive debate preceding Article 47, Directive Principles of State Policy. One of the honorable members on the lighter side, and he says this. He said that I have never spoken in my life. I never used to participate even in debate competitions. In this Constituent Assembly debate also, I am speaking for the first time. But I feel so strongly that I want to speak. So there is a detailed debate which I have not quoted, I have annexed, so that your lordships can get the immediate reference. Duty of the state to raise the level of nutrition and the standard of living and to improve public health. The state shall regard the raising of level of nutrition and standard of living of its people and improvement of public health as amongst its primary duties, and in particular, state shall endeavor to bring about prohibition of consumption except for medicinal purposes of intoxicating drinks and drugs which are injurious to health. The Honorable Court would notice, and your ladyship remarked, that here the word used is intoxicating drink, because the Parliament wanted to give a little expansive meaning, because apart from intoxicating liquor, there are drinks like bhang, etc. Therefore, my lord, it's an expansive meaning. Now, my lord, this is considered in one judgment where your lordship's court, my lord, quotes SHRI. Please see, my lord. The importance of Article 47, this is Ashok Lanka versus Rishi Dikshit. The importance of Article 47 of the Constitution may have to be noticed, tracing the history back from the date of constitutional debate, with a view to find out the intent and purpose for which the said provision was inserted. Shri So-and-so noticed that all sections of the society, including Mohammedan community, whose social habits were reinforced by the Quranic injunction in relation to intoxicating liquor, supported the insertion of such a provision. Consumption of intoxicating liquor in Quranic culture can never mean non-potable. It has to be potable liquor. The prohibition of intoxicating liquor had long been a part of the policy of Indian National Congress. Congress would never have a policy for non-potable industrial alcohol. And its inclusion in Article 47 received support from the Mohammedan community whose social habits were reinforced by the Quranic injunction against intoxicating liquor. In considering the directive in Article 47, it may be observed that the alcohol, the intoxicating ingredient of liquor, is a narcotic, a word replaced by the word depressant to describe the same effects, contrary to the popular belief that it is a stimulant. It is not mere accident that intoxicating liquor and dangerous drugs have been clubbed together in Entry 8, List 2. This is, commentary of Honorable SHRI. Lord, please come to, now the main question, why there are two different expressions used. Lord, I'll read 3 or 4 paragraphs, but just let me paraphrase my submission. So far as Entry 8, List 2 is concerned, Lord, prima facie, textually, contextually, it means, a beverage which can be consumed, which has the effect of intoxication. Will have or will not have, or it is alcoholic, etc., etc. Therefore, with a view to ensure that the legislature providing for the taxation of non-potable liquor can decide the incident of tax. But it is not saying intoxicating liquor. But kindly in this context, please see para 32, para 35 and page 32. That's the only distinction, which we can get. These words, expressions.
If you look at it, in support of what you are saying, which is that alcoholic liquor for human consumption is a species of intoxicating liquor, right? So, intoxicating liquor will include a variety of products, a variety of products, I'll say, of goods, including alcoholic liquor for human consumption. When the legislature imposes a tax, it has to impose a tax with clarity. Therefore, they identify the product itself, namely alcoholic liquor for human consumption. When it comes to the regulatory power of the state, that regulatory power of the state under Entry 8 is couched in much wider terms than the taxing power, for the reason that when you regulate both what is legal and what is illegal. So, the idea of conferring the power on the states to regulate intoxicating liquor was to allow them to also deal with
after effects, social effects, etc.
And where the intoxication may not be due to alcohol, but non-alcoholic intoxication also in that liquor. So, the alcoholic content of the liquor may be one source of intoxication. But to give regulatory, suppose they were to use the expression instead of intoxicating liquor in Entry 8, suppose they were to use the expression alcoholic liquor, the states would not have the power to deal then on a regulatory basis with other things which are not exactly, which are not alcoholic. but which are intoxicating nonetheless. So the regulatory domain of the states was widened as compared to the taxing domain, because the taxing domain has to be always extremely specific, because you have to specify what is the taxing event.
I'm grateful, my lord, that I could not have put it, my lord, that more succinctly than that. For example, my lord, for regulating the consumption liquor, the liquor which is meant for being consumed, the state may need several regulations. Don't drink in public in some circumstances, don't do certain things, etc., etc. And we trace the history in Britain, because ultimately a 1919 Act, 1935 Act had an impact. We were a British colony. And even in the Constitution, so far as some expressions are concerned, it has the British imprint.
Is much wider than alcoholic liquor.
Yes.
That's what you are driving at.
Yes. Number two, while providing for a taxing entry, the taxing statute will have to define the incident of tax. For example, excise, when the liquor is manufactured. Which liquor? Liquor which is ultimately going to be used for human consumption. For example, under entry 52 list 2, taxing power of the state, same expression. Alcohol, liquor for human consumption.
So it specifies the taxing event.
Taxing event.
It is alcohol.
Incident
but
of.
It is defined with the reference to the purpose.
Yes, purpose, and it necessarily involves human being, because the word intoxicating means someone is getting intoxicated. Here for the taxation purpose, it's not necessary. You manufacture alcohol, whether it is potable or non-potable, the taxing event takes place. Whether it may be consumed, may not be consumed, it may have X intoxicating effect, Y intoxicating effect, the taxing statute is not concerned. Therefore, it is only in the taxing entries that the word alcohol for human consumption is used. That I am manufacturing, I am liable to excise. I am selling at this point of time when the sale, your lordship knows about several judgments, whether sale takes place at the time when the contract is entered into, or when the delivery is done, or when sale is complete. That's a matter of separate argument in taxation. But then for defining incident of tax, they put it in a general way that whenever you produce alcohol for human consumption, this is the incident of tax.
That is the end use of that product.
Is
it the basis?
If it is to be regulated other than tax, fiscal regulation, then entry 8, list 2.
But for taxation, it is the end use of that product.
Which is relevant, yes.
It is relevant.
Yes. But at what point of time it becomes taxable? That is entry 86 and 52, respectively of list 1 and list 2.
But, just as Brother Oak said, intoxicating liquor is wider than alcohol for human consumption. But according to you, even in the intoxicating liquor, it has to be something which is intoxicating to a human being.
Yes, has to be, my lords. Because the word intoxic, otherwise it loses its meaning.
That's right. Not necessarily alcohol. For instance, you have all these classical cases on somebody being inebriated with the distilled essence of mahua flowers.
Yes.
Right? Locally, they taught that case to us when somebody was, But so that is not alcohol. I'm not conversant with it. I may be wrong.
Mahua is the raw material for an alcohol.
But mahua flowers
in Gujarat, it is quite.
But you can still regulate it as can you regulate it as intoxicating liquor?
Yes, mahua, yes. No, not mahua flower per se, but the mahua alcohol, mahua liquor. Mahua is converted into liquor.
Into
supposed to be stronger than the regular liquor.
But what are those intoxicating substances
Bang,
which may not
Lord,
be
for example.
alcohol?
Bang, for example.
Bhang does not contain
Non-alcohol.
alcohol. Bhang does not contain alcohol.
No, bhang does not. It contains some narcotic substance. It's a non-alcohol, it's non-alcoholic intoxicant.
It's not liquor.
Not liquor. It's not liquor.
Lord, bhang is a separate item even for excise.
It is
Not a liquor.
Yes, yes, it is uncontrolled. Bhang is the worst intoxicant.
Lordship goes to Konkan also to take coconut trees starting brigade.
I was just going to ask Tadi, Neera.
Neera, yes. After evening, Neera becomes toddy.
These are what's called self-generating alcohol. Kashayams and all Ayurvedic medicines. Alcohol itself by internal fermentation is generated.
So, for instance, when in Kerala, if you go to Kerala or even Goa, in the evening, there's somebody will come to the coconut palm, climb up in a moment and get you the toddy. You have it. It's very extremely pungent, but it's not alcoholic.
no.
You
It
keep it in the
becomes
morning, it
by the
becomes
evening.
alcohol.
Keep it for the day.
It becomes alcoholic.
It becomes after in the evening.
Pulled down from the tree, it's tapped from the tree, it's not alcoholic.
It's
You
not.
may still not be able to have it because it has a very distinct odor.
As the
But
day
it's
goes
not
by,
alcoholic at all.
Therefore, the
fermentation-
toddy shops are
fermentation-
fermentation takes place, then it becomes alcoholic.
Yes, toddy shops are closed after afternoon.
So many times on the highways in
That's
Maharashtra,
getting
you will
fermented.
find these little steel kiosks which say, Yete Neera Vila hai.
So Nira becomes Madi, then Madi becomes Tadi. That was I was told in Konkan.
No, even in UP, Lord, Nira is had in the morning.
He is right. He is right. Mr. Datar is right.
But even,
In our younger days, we used to go to the village. Get morning Nira, it's quite tasty and fresh. But
even
when it's fermented, it becomes more and more.
So therefore, Gujarat being a prohibited state, all Neera shops are closed after 2 o'clock because then it start getting fermented.
Fermentation process starts.
but that is alcohol.
It becomes alcohol.
It becomes alcohol.
Lord, now, my Lord, I may show some history.
They did not permit to carry. Even we have it today. We used to have it. Not, I think that is wrong. Toddy even had today, Lord, is delicious. I mean, sorry, the Nira.
Neera.
In the morning,
Delicious.
yes.
Yeah, it's delicious. And it's healthy. They say it's healthy.
That is our doctor, right?
Delicious is a subjective thing, but yes, it is healthy. No, sir. It's pungent. But then,
No, Nira is not.
Nira is not.
What Mr.
Neera
Dwivedi
is like
saying that,
earlier,
what Mr. Dwivedi is saying that even Solicitor General can have Neera.
Yes.
Toddy is pungent.
Toddy is.
But he talks of alcohol.
Yes, Neera is not
elsewhere.
toddy.
My friend talks of alcohol. He recites the couplets also about alcohol flowing from the eyes, perhaps.
Lord, para 42, Lord, kindly see, Lord, one of this argument, one of
The only point which they have been trying to make is that the word intoxicating per se does not exclude intoxicating liquor which is not for human consumption. That's their case. So,
that is para 42. I wanted
Para
to
42.
Yes, Lord. Because it should be consumable. You cannot make it drinkable. It has to be a beverage.
para 42.
42, my lord, at page 34. Secondly, the term intoxicating liquor would necessarily mean a product which can be taken as it is, by which one gets the effect of intoxication. It may be possible that some form of industrial alcohol, that is non-potable, may bring the effect of intoxicant if diluted or mixed with some other chemical or taken in a particular manner. Entry 8 list 2, however, consciously covers the field for a product which is capable of being consumed as it is. for bringing the effect of intoxication and not something which is not an intoxicating beverage but has the potential of being converted into an intoxicating drink. But you can't go into the market and say that give me denatured spirit or give me ANA and then mix it with something or dilute it with something. It has to be consumable as it is, as a beverage, which gives the effect of intoxication to a human being. Otherwise, Manoj, there is impossible to reconcile this. That center has non-potable, state has potable. 43 also. So para 43 at page 35 also. But I have given the distinction that something can be used, something can be abused. Please see, Manoj. It is submitted that as far as possible, a common parlance understanding and meaning shall have to be given to the expressions used in the Constitution. The common parlance understanding of the expression intoxicating liquor is an intoxicating beverage containing liquor and having the effect of intoxication, and merely because some other form of alcohol, that is industrial alcohol, etc., can be abused for getting intoxicated after making some changes in the composition, would never be falling within the meaning of entry 8 list 2. And there is a reason, Manoj. There is a reason. Not entry 8 is a regulatory entry. Suppose we read in intoxicating liquor, even non-potable alcohol. Would the state, I'm posing a question to myself, regulate that when you buy non-potable alcohol, namely ANA or any industrial alcohol, I hereby regulate, don't add more than 30% weight for volume water or add more than 50% volume per water. That's not regulation contemplated.
But there's only one area, Mr. Solicitor, one area, just consider it. Suppose there is some kind of, and there is now as we know, intoxicating liquor, industrial alcohol, or I can say denatured spirit. Industrial alcohol is an inappropriate phrase. Denatured spirit, which can, and we know that it can, be converted into intoxicating liquor, either by a process or by whatever. Now, if that possibility of abuse is there, can we deny to the state its regulatory power to ensure that the abuse does not take place? I'll tell you why. Center is, it's not pejorative. Center is a disconnected entity from the states. You're a national entity. You're not going to control, what's happening in every district, in every collectorate. Suppose there is a strong possibility of denatured spirit being misused for the purpose of consumption. State is rightly concerned as the custodian of public health. I don't want this liquor tragedy to take place within my jurisdiction. So state can impose regulations for ensuring that abuse does not take place. If we concede to that state the power to regulate for the limited purpose, even assuming you are right, that entry 8 covers only intoxicating liquor and liquor which is therefore intoxicating for human consumption. The state is still keen on ensuring that somebody else does not use a product which may be of grave danger to public health by misusing the nature of the product. They can make regulations limited for that purpose. And as an incident of making regulations for that purpose, why should we deny them the power to impose fees for that purpose?
Not fees. The regulatory power, my lord, would be not to consume that, my lord. And
not to consume it. Or, for instance, you must, if you are transporting denatured spirit, that you must have whatever passes, licenses, or that you will transport it under certain conditions, declaration in a certain form. variety of regulatory programs.
That can be done by the center. I'll show my lord from IDRA. That is what is contemplated. For so far as
Can the state not also say, look, this is happening within my territory. This is likely to affect, and we now know that these tragedies, tragedies and all these tragedies
which
take
is
place.
different.
No, I'm just giving you an example that these tragedies do take place. The states are vitally concerned with the health of their citizens. Now, why should the state not have the power to just regulate? And if they can regulate to ensure that there is no misuse, then you can impose any fees as an incident of your power to regulate.
Health is a separate entry 26. Entry 6 in the third list, in list 3, in the second list. But maybe in that exercise of that power they can. But so far as the industrial alcohol, non-potable is concerned, the regulation under the IRDA will have to be by the center. Maybe delegating the exercise of powers to the state. That these are the statutory regulations. Every company manufacturing denatured alcohol will have to get this much these many registers. It will have to make entries. It will have to sell it only to authorized dealers. It will have to ensure that it doesn't go to unauthorized hands. Your police officials will ensure that it is not being used for the purpose of converting clandestinely into something which gives intoxication, etc., etc. But the law will have to be, in my submission, traced under Malot 52 because it is non-potable alcohol. It will not fall within 8. This is how the drink is treated. Intoxicating liquor is treated historically, and that in a short while, I'll just give, if your lordship can come to page 35. How, my lord?
Solicitor, it was argued that denatured spirit can be converted into something which can be consumed. It becomes intoxicating liquor. So, state has power to legislate for regulating something which is prepared by using denatured spirit. Suppose denatured spirit is converted by some process into intoxicating liquor. That aspect can be also regulated by the state government.
I'm sorry, my lord. The argument is fallacious. Denatured.
So firstly, tell us whether it is possible to convert denatured spirit into a intoxicating liquor.
That argument I am respectfully submitting is fallacious for the reason denatured alcohol without any industrial process by some clandestine process can never be converted into a consumable product. It is converted into a product which gives you intoxication. Note, for example, snake bites in a limited quantity gives you intoxication. Some cough syrups have alcohol content, more alcohol content. People drink the entire bottle and get the intoxication. This is an intoxicating drink, but not permitted. When you convert in clandestinely, what they do in the breweries, they convert industrial alcohol into potable alcohol, but by way of methodology, by way of machines, by way of controlled environment, by way of a particular temperature being maintained, etc. And the purpose is to create alcohol, the beverage for human consumption. What we are discussing and what my learned friend was giving an example, it is capable of being converted, meaning thereby we can add something and we'll get intoxicated. But that is not intoxicating liquor. You are clandestinely misusing the product with a view to ensure that you get intoxicated.
The regulatory entry, structuring the regulatory power of the state. So when entry H says intoxicating liquor, it should be very restrictive for us to say that this will apply only to properly so-called intoxicating liquor. Why cannot it extend to regulating those products which are misused for the purpose of selling them off as intoxicating liquor? Because then what we'll be doing is we'll be telling the states that, look, you can't do anything. even though there's a grave danger that this would be used for the
They can
purpose
do
of,
many things, I'll show.
but under the central law, you are saying.
No. Even under the state law. Bro, please see, my lord, how this history has developed. How United Nations used to and still controls the word intoxicating liquor. My lord, we have derived the imprints of this expression from United States.
Therefore, you concede.
United.
You concede. Therefore, you accept, not concede. You accept that the states do have the limited power, whatever that powers we'll see, to regulate
For health. Which is different. Which is completely different, my lord. It's kind of a unauthorized small brewery. What my learned friend is talking about is that I buy denatured spirit, adds water into it, and if I drink,
Constitution. Yes.